Namaste and good evening to all from Abhivardhan, from Global Law Assembly. Here we have another episode from for AI Now, Season 3. And in the last episode, we had discussed about what could be an Indian technological thought. And this time we are actually going to discuss about, I would say, how can the issue of pendency of cases in various courts in India can be addressed. So I came across this very important article or research paper, let us say, by two scholars from IIT Kharagpur. So let me introduce the scholars and of course give a context about the paper which we are going to discuss in this episode for AI Now. We have Shubham Pandey and we have Ayan Chandra. Shubham and Ayan both belong to IIT Kharagpur, I would say. Shubham is currently the senior research fellow there, and Ayan is an MS in computer science from IIT Kharagpur. So, Shubham and Ayan, welcome to AI Now, and it's a pleasure to have you. Yeah. So, I think let's give a context fast so that we can begin the discussion without any further delay. I came across this interesting work on, and let me entitle it first. The paper is entitled Towards Reducing the Pendency of Cases at Court, Automated Case Analysis of Supreme Court Judgments in India. So there are various judgments, various cases in the Honorable Supreme Court which have been assessed. And I think this is an automated case analysis. The authors can explain how they have done it. They claim that using NLP-based case analysis model, they actually have achieved 70 to 90% accuracy. So let's first discuss the inspiration behind the work, and then let's come on to each and every aspect of how they have addressed this, because I think that could be very understandable to understand in simple terms how pendency has been, quote unquote, assessed algorithmically. So let's begin with both of you. I think any of you can give a context. I think both of you should do in any ways, but any of you can begin. So let's start with Shubham or Ayan. Anybody can give a context behind the inspiration of this work. So yeah, you can go ahead.
I'll just briefly introduce to all first, thank you, Ayan, and welcome all the audience. And I'll just briefly introduce to the audience as to what the pendency issue is right now in the Indian judiciary, so that they have a very broader context of what we are going to talk about. So in Indian judiciary, comprising of three levels of judicial structure, which is Supreme Court at the highest level, followed by High Court on the state level, and then we have district courts which are supervised by the High Court in every state. Now, if you look at the total number of cases that are pending at all three levels of the courts, they figure stand at a staggering 4.3 crores right now as we are talking. And uh, uh, these cases, many of the cases are pending for more than 5 years. And in some cases, the pendency is for more than 20 years. So for 20 years, the cases are pending in the system. And the problem is that criminal cases are also pending for more than 20 years. So that was the impetus when I joined the law school. That was the impetus because I wanted to find ways, first find problems as to where the bottlenecks are, and then find ways to tackle those bottlenecks through the means of technology. And while I was doing my research at IIT Kharagpur, I fortunately met Ayan. Ayan was an MS student there, and he was working simultaneously on a NLP-based structure, an algorithm that he wanted to analyze cases through the means of this technology. So we collaborated with each other, and then we took the project forward.
Thank you, Shubham, for setting the context. And I would like to personally also thank you for being the co-author of the work. And it has been a wonderful time working together, I would say. So in this particular case, when I first encountered this problem, I was on a different structure. So that was known as the argument structure. So initially, I was going through all the literature that what has been worked on or what the prior authors and researchers have worked on this particular area. And most of the structures that we have encountered are either of the two categories. One is that they are trying to understand whether there is a claim or major claim, or there is a premise, and whether they're attacking or supporting each other. So that was the argument structure those people worked on. And there was another structure, which is essentially the rhetorical structure. But none of this structure actually addressed what is the underlying structure of these judgments. most prominently the Supreme Court judgments. On the other hand, you have a standing problem of huge number of cases pending at the various level of the courts, either in the High Court or in the Supreme Court. I try to understand what are the systematic, what are the particular things that delay or that kind of, extends the timeline for each, or extends the lifespan of the cases. And can we actually apply the computational method to decrease this time? So there only we identified that, okay, finding the relevant cases for this particular given case, that might be one of the cases. The second thing is that what are the important information that individual advocates want to search in a particular, want to find or want to look for in a particular judgment. For example, it might be the facts, it might be the arguments by the appellants, it might be arguments by the respondent, or it might be the observations, conclusions. So these things they want to understand, in a very, very low latency setting, meaning it should be within few milliseconds. They want to understand, go through the entire judgment, that okay, here in the line number 6 we need to have this particular sentence which is actually saying something about the conclusion, or might be something about the observation. So that exactly we needed to solve. And there, after talking with the legal community, especially Shubham and Professor Uday Shankar and others, I understood that structure is lacking. And there we defined this particular structure, and thereafter we proposed a pipeline based method, because it's a combination of rules and different NLP tools, if I put it like this. And the pipeline worked quite well. So initially we took the air pollution cases under the environmental category, and there it was like, between all the cases which are done against the government. Here again, the government is precisely, I'm mentioning the central government or the union government. So the cases which are actually against the union government, so those 28 documents we took from them. Out of the 28, 24 documents we analyzed, annotated, and then fed it to our pipeline, and it evaluated on the remaining 4 documents, and it worked really well. I think that's quite a brief understanding of what we actually did and where are the issues are lacking, that I set the tone for the discussion. Over to you, Vivek.
Thank you so much. So I was just going through this 8-page article, and I think it's a beginning, I would say, in terms of understanding case analysis. And I completely sympathize about the fact that when rhetorical role labeling is done, and of course case analysis is to be done, I completely understand how certain portions in many such judgments which you have assessed are not so easy to be found out. Otherwise, of course, there are so many Supreme Court cases. You yourself said that you limited it to certain issues. So let's understand uh, the kind of case labels that you took. Now, you took case analysis labels like legal issues, argument by appellant, argument by respondent, argument by amicus curiae if necessary, relief pair, observation findings, legal principles, fact, rationale, conclusion verdict, interim order, compliance. Uh, you generally state, and it is already in the work also, that there have that you all created a corpus of 28 Supreme Court cases which are related to air pollution, and they were annotated in the case analysis structure. Now, uh, let's understand how was the whole procedure made simpler, and why is it that only these specific cases were taken? And I'm only asking out of curiosity, because this could be a very interesting benchmark to understand how in future it could be done. And then I can also come on certain applications and certain software which are already there in the Indian legal field to decipher Supreme Court and High Court judgments using AI. So that is a different thing I'll discuss. But on this, if you can, so we can do it either ways. Shubham and I on both. Anyone who
Yeah.
wishes to begin.
So I'll
Yeah.
just lay down the context of why we choose those labels, and then maybe Ayan can tell you why we chose only 28 judgments and why we chose air pollution cases in specifically. So if
Yeah.
since I have a legal background, I come from a law school. Uh, what I perceived was a traditional way of doing case analysis, and we have been doing it time and again. The same traditional way of doing any case analysis, whereby we identify what the facts are, what the arguments were, what the issues that were raised, what were the rules or the legal standing, what is the rules that are mentioned in the statute, and how the judges or the magistrates have applied those rules to the issues at hand. So this was a very traditional, very classical way of doing a case analysis. But then the technicality or the difficulty was how to teach a machine to understand these labels. I mean, that was a challenging task for us, because as human beings, it is quite easy to learn these things, and over time with practice, we get proficient in that. But we have to make a machine understandable in their own language as to what these labels are, what their true import is. And that was a very challenging task, and maybe Ayan can now highlight what challenges he faced while teaching the machines to learn these and understand these labels. Yeah.
Okay, so I would like to touch upon this particular reason that why exactly we to choose this air pollution cases. So there are very few reasons. So one of the reason is obviously that what is the broader scope of this issue? How grave is the issue? So as we know that environmental issues are very crucial in rapidly developing country like India and other Commonwealth nations, and it's a category that has a close relationship with all the national sustainable development goals as it is projected, and also it's a part of the United Nations climate action requirement. So it is very important. So legally speaking, this is also important. Second is that these cases are very broad as they cover an application of a wide range of different laws. I mean, it should not be necessarily limited to the environmental laws or Air Act or Water Act or something like that. It may be any other law that can be applicable. So we have also seen that in the documents that there has been certain cases where the right to livelihood is also been highlighted. So that is again important thing. The second part is that there are a mention of lot of unenumerated rights. Now, while we are designing a particular pipeline system or computational system, we need to look for all the different possible scenarios, even if we are taking a smaller data set, or even if we are taking a smaller subset, right? In most of the corpora, if you look into the traditional civil corpora or the criminal corpora, most of them are dealing with the enumerated rights. But this is one of the particular interesting area where you have a mention of lot of unenumerated rights. For example, right to pollution-free environment, right? So that has become a good example for a study. The third part is that there should be an existence of multiple stakeholders. For example, here, if you look at the appellants, there might be multiple party. In each of the cases, it is always a multi-party case, if I put it like this. So there are a lot of appellants. There might be some amicus curiae and and usually one of the respondent is the central government. So if, for example, you have the different government bodies, state government. So there was a particular case where it was like the air pollution of the Delhi, which is actually happening due to first the firecrackers. Second, it might be happening due to the stable burning in Punjab, Haryana, and NCR region. So that is another issue. So there, the state government of Punjab, state government of Haryana, and the Delhi government, meaning the state government, they all become party in that case. So the message is here you have multiple different government bodies, administrative bodies, National Green Tribunal, etc. becomes involved in these cases. So it's always an important stakeholder heavy case, if I put it like this. Computationally, what it means, there will be multiple appellants, multiple respondents, and we need to identify that what are the individual appellants are saying, what are the individual respondents are submitting. In this particular work, as we can treat this as an initial step forward. So here we have used that, okay, all the appellants, we have just replaced it with the token appellant, right, or the appellant token. But later on, if somebody wants to take this work forward, they can even differentiate between the appellant 1, 2, 3, and etc. If they wish to, that possibility is given here. I think I broadly address that why exactly this air pollution cases are really interesting, if I put it like this. any questions so far, or if I have missed anything, you are free to jump in and help me out on that.
No, I think
Sure.
you covered very well. Yeah.
Yeah, you go ahead. You go ahead. Yeah.
Yeah, so
Uh,
what I
sh-
was saying is exactly he covered it very well, and to aptly put it, air pollution and specifically environment related cases are like it is beneficial for everyone. So the prime focus was to pick those areas which are not as explicit in the law books, but then over time the Supreme Courts have developed it through the mechanism of expanding the ambit of Article 21 and right to life, and then including all those aspects. So that was the challenge we took. Yeah.
That's interesting.
one
So
one more thing I would
you
like
go ahead.
to
You go ahead. You
sorry
go
to
ahead. You
interrupt.
go
Yeah,
ahead.
yeah.
Yeah.
One more thing I'd like to add it here. I think why exactly the number 28? It is nothing but we took a decade-wise corpora. For example, here the air pollution cases which are from say January 2010 to 2021. So in between all the cases that has been done against the central government. So that count was 28. Just to mention that it's not a randomly taken, but it's a well thought corpora part of a particular decade long document set of documents. So that helps us to also understand that if there is any evaluation of the from unenumerated to enumerated, if anything has moved for further study, somebody can also take advantage of this. That may also be a stepping stone into that direction.
There are many domains, and of course, just from environment and whatnot. But just curiosity, if we say that matters related to, and I don't know, I mean, and this has, addressed multiple based cases. I think there may be finance-related issues which are dealt in the Supreme Court, or competition-related issues which are also very critical. Sometimes they're budged or not. And as speculating, they also could be as in maybe just that could be helpful as you more interested. I don't know if you will, but if you do, I really wish. So I think just inside the cases alone. So that is something which I humbly appreciate. And the profitable. Just need it. Yeah, I think it's better now. I think it's audible from my side also,
Yeah,
and I
now
think
it's audible. Actually, your
Shubham is
voice
back.
was breaking. Yeah.
So
Yeah. Yeah.
yeah, yeah, I understand. So yeah, I was saying that as far as environment law is concerned, it's an interesting work. I think in future maybe you can try something called finance laws and competition law also, because matters related to economic issues and civil liability can also be addressed. And I think it would be very interesting to see how stakeholders do it. Of course, it could be a little bit murky policy wise, but it's very interesting to see. Although environment is a soft area in my regard, I think chalo theek hai. Environment analysis hota hai, then it's still not something which is like, okay, oh, you know what? It is concerning. Of course, it's concerning like others. Like I think taxation, finance, and competition also have their specific roles. So I think in that sense, I said. So let's come on to certain more aspects, and then I think we can conclude faster. Uh, I think you developed a particular prediction framework. Uh, you identified what rules for each and every sentence which you do. I think it's a very beautiful map. I can share the screen if I wish to. So I think I can just share it for the viewers who watch and also who binge watch. So here we go. Yeah. So I think it's visible now.
Yeah,
Yes,
it's
Scanning.
visible.
Yeah, it's visible. It's visible.
it's visible. So this is the framework which I really found it interesting. How do you address it? And I think this is something which is quite, I would say, unique. So let me come on certain companies which are trying to get into this field particularly. Now, there's one institution called, I think, a company called CaseMind, which is in Noida, and they're already trying to analyze various high court, district level civil and district courts, as we know, and other kinds of courts at the Kachari level, quote unquote, and the apex court plus the, I think, even the British era courts, if I'm right. They're trying to come up with a collation of their judgments. I have used them on wherever I wish to, and I think that's something which is very interesting. Line by line, they have a quite different perspective, and they try to collate it. So I'm not asking, I mean, I'm not saying this is a startup project. I'm just saying this is something which is interesting, but it is impactful. Who knows, maybe you could turn out to be, and we should embrace entrepreneurs. But how do you see it? Do you find inspiration, or did you do something in a completely, I would say, different sense? Of course, the corpus was specific, but how do you see it? Just curious to know, out of good faith, I'll say. Yeah.
I think
Okay.
Ayan can take this question. Yeah.
Yeah. So there are two parts to it. One part is that when you have something which you want to analyze, that is mostly in the, as we call it, the lab product. When you have the lab and you have in a particular setting, you know what are the different annotations and how do you want to evaluate it. For example, what is the accuracy of the individual levels? It may be in the precision recall or F1 score, however you want to put it, you know that what are the accuracy. But here you have a very pretty much, if I put it like a homogeneous corpus. Homogeneous meaning all the documents are relating to one particular kind of issue. For example, the environment or the air pollution, right? But when exactly you are going into the production from lab to market, then there is a ton of unseen cases they want to use it. One way would be like, this controlled vocabulary and rules, we can tune it or we can make it very, how should I put it, make it partitioned in different categories. That is one way of looking at it. That might be immediately helpful and impactful for the users. The second thing is that if we consider some form of user perspective, some kind of user in the loop system, that might be also helpful. For example, the initial users may be able to see some erroneous result might be, then they can correct it, which is like, the beta testing phase. In that particular way, they can actually deal with they can actually improve the system if we put the user in the loop system. That is one way of looking at it. The third part is that how do you, from business perspective, how do you want to use it as a service? Then it might be that somebody can take up this project, they develop it, and they made it more scalable, and then as a service they can provide it to all the different legal tech companies. So it becomes itself a legal tech ideation, if I put it like this. Or that is exactly its proposition, business proposition. The other question would be, okay, this becomes uh, a very much in-house development for each of these existing legal players, and they just try to make it on their own, and just they can take help of our paper and they can make it of their own and with further modification. But my suggestion and experience from, so I have been in a insure tech for some time for my own interest. What I see that for each of these cases, no one single system is going to help you. It is always should be augmented by multiple different things. For example, you will have this framework or pipeline, but for each of the individual boxes, for example, the rules to identify the arguments, or to rules to identify these particular conclusions, you always need to change something or modify something. So the base we have given that this is the bare minimum rules is there to start it, but you also need to append it with something more. That is always there. The third usual part would be that how exactly you make this store these rules essentially. So the rules are going to be stored either in the regular expression or into a language grammar format. So that might be one way of looking at it. Then how fast you can retrieve the rules and apply on the document. So there are a lot of different technical perspectives are there to be addressed in each step of it. I think that is, I know that is very open, that is very much specific to each of the companies how they want to implement it, and I'm very much open to like for a discussion that how can one is willing to scale this thing up.
Yeah. To add on this, just out of enthusiasm, I guess that we have this genuine demand in the legal profession that judgments which are delivered, I mean, except except complicated matters like arbitration and taxation, where it ought to be, which again is a different matter altogether, based on the legal erudition of the councils and the judge and all the stakeholders. I think many judgments in high courts and the Supreme Court are very lengthy, and when we compare them to even the Anglophone courts in UK, US, and others, we see they're very crisp. So I think the errors that you all pointed out, there was a particular portion in this paper with regards to the issues, and of course, you mentioned that when you had gone through a set of 24 legal documents, you had mentioned certain, I think, two or three or more issues. Yeah, five issues specifically. Like for example, in some of the paragraphs, the third person pronouns are not properly co-referenced to the appropriate named entities, so the sentences do not have any appropriate identified token, example appellants, and all of those. Then you also mentioned about interim orders. In the case of them, it was difficult to evaluate whether a sentence can be identified as an interim order or a conclusion, even if, even though reliefs are asked, and so many. So I think viewers can read it, and I think they can learn out of it. So just came out of this, maybe just out of a curiosity, maybe for future learners and people who are interested, it could be a case to assess judgments and see how much erudition can be addressed, and how algorithmically people can learn to upskill themselves in these aspects also, because when you're drafting a judgment, and I'm not saying about judges specifically, I'm saying even about writs, because many writs, if you also will see, P or PILs for that matter, people file, but either they are very juvenile or they are very long, but on legal arguments, it's not specific. But you have to be specific in legal arguments to put forth your case, whether it is any matter per se. So I think with this, I'll conclude, but I'll ask a final question to both of you. What are your future plans post this paper, as far as the inspiration from this paper came in? And how do you see it? As far as, if you know about your co authors, what do they think of it, who could not attend? But of course, both of you in general, what do you think? Yeah.
Yeah, I'll ask Ayan to just go ahead and then maybe I can talk about it.
Yeah, one part is definitely, as I was also discussing with Shubham, that how can we actually it should not be always limited to only a particular set of tools. It should be also addressed that what are strategically and policy wise, how can exactly we reduce the pendency. So this particular tool is only game changer in terms, if I put it game changer, I am putting it, but you can also have a little bit of other comparisons. What I'm trying to say, this tool is an initial stepping stone in addressing the problem and solving it wherever technically possible or computation possible. You can modify the rules, you can change the boxes, but this is one of the framework which you can follow to solve this problem. The other way is that strategically, how can you identify the cases? That is one part. And when, how long you can let the pendency go on, that's a crucial question, because it's not always possible. Pendency will always be there, but when exactly you need to shut the door and say that, okay, hey, let's first complete this one, that part. I think Shubham will take forward from here, because it's a lot of thing to do with Shubham's. I think Shubham's, it is related to Shubham's dissertation also. I'm not very sure, but I am guessing, but he can
Yeah,
actually
you have guessed
comment
it
on this.
right. You have guessed it right.
Yeah.
I've been working on this issue for a long time now. There are a lot of things to begin with. I mean, the list of to do things in order to reduce pendency is so long that we can have many podcasts about it, have many research papers about it, and still we will be falling short of what to do. But where exactly our paper and our tool or our algorithm fits is, I'll just take you in a minute or so to a background as to where we were standing and what changes we brought into the system, which made our work, made our lives very much easier. So just imagine few decades ago, whereby legal research or maybe legal search was such a tardy and tedious job. identifying the cases that were delivered by Supreme Court in the form of precedents or high courts, finding them in the library was such a tedious job. Just you can ask any of your law professors or maybe advocates, and then they'll tell you what life was before, before legal search engines like Manupatra or LexisNexis came into picture, and how legal profession changed, just overnight by introduction of these legal search engines. And thereby our tool also becomes a game changer, very rightly said, whereby, sitting and understanding a legal judgment delivered by Supreme Court and High Court, which is of like 700, 800, 1500 pages long judgments, and then picking and choosing those important things out of it is like again a nightmare. Our junior associate who is given the task to, identify the precedents in a particular judgment, let's say Ram Mandir judgment, identifying the precedents out of 1500 pages of Supreme Court document. I mean, that is a very challenging task. But where our tool comes as a game changer is the moment you fit that, judgment into the system, it will automatically translate and pick and choose all the important things, present to you in a very crisp, maybe I would say 5 to 6 pages document, all the important, aspects of facts, observations of the court, issues that were raised, and what the precedents are. And that will, definitely, modernize or change the legal system as we are seeing it now. So yeah, I mean, we can take it forward in that way. So it is just a module to addressing the problem of, delaying of cases in the court. It's not a like a solution for all. It's a module to, understand the problem and then put the right thing in the right place, and maybe it can make some changes in the system. Who knows, in the times to come.
Yeah, that's interesting. So with this, we conclude this episode of AI Now, and we look forward to such enriched discussions in future. Maybe if you come up with another interesting paper on this, would be happy to invite you again, and we'll stay in touch as things develop. I would just request you to stay for 1 minute post the end of the broadcast for feedback reasons. And till then, I'll say to the viewers that it has been a pleasure hosting Ayan and Shubham. And those who watch and binge watch this, thank you so much. I think a lot can be contributed in this field towards the issue of pendency of cases, and I think a lot can be sought in that way. Till then, Namover, thank you so much. Sayonara.
Thank you.